Welcome to Guiding Growth, Conversations with Community Leaders. This series convenes leaders on a variety of topics concerning our business community and is presented by Dignity Health Mercy Gilbert Medical Center, Phoenix Mesa Gateway Airport, with further support provided by Cox Business and Arizona State University. Our sponsors, unfortunately, are unable to join us today, so I'm going to share a message on behalf of both Dignity Health and Phoenix Mesa Gateway Airport. Dignity Health says COVID-19 vaccination is recommended regardless of a person's history of prior symptomatic or asymptomatic COVID-19 infection. Thousands of Arizonans have already received the COVID-19 vaccine. In fact, it's estimated that 1 in 5 Arizonans who have received the vaccine were vaccinated at one of the sites in the Southeast Valley. However, vaccines are just one tool in our toolkit to prevent the spread of COVID-19. So even with the vaccine rollout underway, the pandemic isn't over yet. Dr. Omar Gonzalez, epidemiologist for Dignity Health in Arizona, reminds us that it's still important to wear masks, practice social distancing, and wash our hands. It is up to all of us. Please do your part to slow the spread of COVID-19. Spread kindness, not COVID. And now a message from Phoenix Mesa Gateway Airport. The Phoenix Mesa Gateway Airport Authority is seeking a master developer for 400 acres of land envisioned to be a mixed-use district featuring retail, industrial, and office uses. The area, called Gateway East, is located east of the airport along Ellsworth Road in Mesa. The new airport terminal will also eventually be constructed on the east side of the airport. The airport will continue to own the land as it is developed, and development is anticipated to take several years. It will include no aeronautical buildings. Large non-aeronautical developers are encouraged to respond to the request, and the RFP is expected to be issued at the beginning of May. You can visit gatewayairport.com for details. And so again, thank you to our sponsors for making today possible. The Guiding Growth series is brought to you through a collaborative effort between the Gilbert Chamber of Commerce and the Town of Gilbert's Office of Economic Development. And typically at this time, we would have Jen Graves join us, or Dan Henderson. Jen, I think, is running just a few minutes late, so we will catch up with her towards the end of the program and have her say a few words. So as we get started, you're going to notice at the bottom of your screen a Q&A option, and you can submit your questions throughout the presentation using this option, or raise your virtual hand within the participation tab, and we will be able to call on you. Glenn is going to facilitate the questions towards the end of his program. And so it's my honor today to introduce to you our guest speaker, Glenn Pelster. Glenn is licensed to practice law in Colorado and Nebraska, and his Arizona bar admission is pending. Is that still the case, Glenn?
It is. Yeah, COVID slows everything down a little bit.
Glenn started his legal career interning with the Equal Employment Opportunity Commission in Washington, D.C., and joined Employers Council as an employment law attorney in the Colorado Springs office in 2013. For the past 5 years, Glenn has operated his own law firm in Nebraska, serving clients in a variety of legal matters across western and central Nebraska, specializing in counseling and litigating employment law issues for both employers and employees. Glenn rejoined Employers Council in 2020, where he shares his experience in training HR professionals and managers on employment law issues, as well as conducting wage and hour, independent contractor, and general HR audits. And with that, I'm going to thank you so much, Glenn, for joining us, and turn it over to you.
Thanks for having me, Sarah. It's a pleasure to be involved in the conversations in this ever-changing area of law. As everyone knows, Prop 207 passed in November, and as of November 30th, recreational marijuana sales became legal. Now we actually have, as of about a week ago, recreational sales actually occurring. So it does represent an ever-changing area of law. For those of you who don't know us, Employers Council is an employers association. We have nearly 200 licensed attorneys and certified HR professionals, and we have over 80 years of existence. We provide every manner of employment law and human resources consultation, and we've helped employers navigate tens of thousands of issues as they're ever evolving. So our model is membership based, and it allows us to provide high quality services at a fraction of the cost of other options, while uniquely combining the HR legal support to ensure that we address each of our members' specific needs. With expertise that spans virtually every aspect of employment law and human resource management, we are your resource for everything employment related, including policy development, day-to-day consultation, performance documentation, and termination. I do have to give you a bit of a disclaimer. Because this is an ever-changing area of law, my comments today are based on what we know as of today. We can't predict everything that happens in the future. These laws and statutes are going to be analyzed by the court, so just keep in mind that things could be changing. This is not intended to be specific legal advice. If you do have a legal question, I may actually defer to answer that until we get off the screen, because some of those are not appropriate to answer. And I'm not allowed to offer legal advice to anyone who is not a member of Employers Council. And you have to be individually authorized by our members to receive legal advice. So today is just informational, right? So what are our objectives today? We're going to determine how Arizona's new recreational marijuana law will impact current marijuana laws and will impact employers. We'll learn how employers need to prepare for recreational marijuana in the workplace. Arizona marijuana law can be broken up into 3 specific statutes. The first is the Safe and Smart Arizona Act. That's the term for the act that was passed under Proposition 207 and has been codified in statute as is cited there. We also have the Arizona Medical Marijuana Act. That's been around since about 2010. And we do bring that back into the conversation because what we find is people often aren't aware that some of those changes in that act actually affect employers more than the passing of recreational marijuana. Finally, we have the Arizona Drug Testing of Employees Act. And that statute dictates how employers are supposed to conduct their policies and treat employees when they do employment-related drug testing. And both recreational and medical marijuana are impacted by this act. So if you are going to continue testing, it is important that you take notice of the Arizona Drug Testing of Employees Act. But we'll talk about each of these in a little bit more detail. So with Safe and Smart Arizona Act, or Prop 207, it passed in November, and the law, because of the way the Arizona Constitution works, actually came into effect when the governor certified the results of the election on November 30th, 2020. It legalized the possession and use of recreational marijuana for persons who are at least 21 years or older under certain circumstances, and it regulates marijuana sales and taxes. So what happens now, now that that law is actually in effect, possession became illegal immediately on November 30th. And a lot of people don't understand that and didn't understand that, but possession is still legal. The Department of Health and Human Services has until April 5th of 2021 to completely establish its regulations. And first legal sales started on January 22nd, 2020. I apologize, 2021, there's a typo there. When some medical facilities actually received their recreational permit. So we do currently have recreational marijuana sales legally occurring in the state of Arizona. So how does the Safe and Smart Arizona Act affect employers? The provision actually provides that this chapter does not restrict the rights of employers to maintain a drug and alcohol-free workplace or affect the ability of employers to have workplace policies restricting the use of marijuana by employees or prospective employees. It also does not require an employer to allow or accommodate the use of, consumption of, possession, transfer, display, transportation, sale, or cultivation of marijuana in a place of employment. So effectively, the Safe and Smart Arizona Act actually relieves employers of the obligation to worry about marijuana. You are still allowed to test for marijuana. You are still allowed to discipline employees for use of marijuana while at the workplace. And realistically, you're still allowed to have a standard policy that employees who utilize marijuana aren't going to be employed with your company. This essentially means that the Safe and Smart Arizona Act doesn't actually affect employers. Where we find the Arizona law actually affecting employers the most is the Arizona Medical Marijuana Act. It was passed in November 2012, and it legalized marijuana for medical purposes. The very interesting thing about Arizona's law is that it actually put protections for employees who receive a medical marijuana card. So this statute prohibits employers from discriminating against a person based on either their status as a medical marijuana card holder or a card holder's positive drug test for marijuana components or metabolites. What this means is that if you have a valid card holder who tests positive under your drug testing policy, you may actually have to make an accommodation in how you treat that employee. So if you're going to conduct marijuana testing, the first question that you're going to have to ask yourself is this person a medical marijuana card holder or not? If they're not, in accordance with the Safe and Smart Arizona Act, if your policy is to terminate anyone who tests positive for marijuana, you can do so. But if they are a marijuana card holder, then you actually have to follow through with some different procedures to make sure that you are not violating that statute. Okay. There are some exceptions to the Medical Marijuana Act discrimination provisions. The first is that you're not required to employ a medical marijuana card holder if doing so would cause a loss of monetary or licensing related benefit under federal law. You're not required to allow card holders to use, possess, ingest, or work while under the influence of marijuana, and you may reassign an employee performing a safety-sensitive position if they are a medical marijuana user or card holder. So, what really happens when we're talking about loss of monetary or licensing benefit under federal law? You're really talking about federal contractors who have, or recipients of grant funds or other types of federal funds that have drug-free workplace clauses. So those provisions that would cause you to not receive your entitlement under that contract, those are going to be the provisions that allow you to effectively discriminate against marijuana card holders or refuse to employ them. The other piece is Department of Transportation licensing requirements. So if you have individuals who have CDLs who have to comply with drug testing requirements under the federal government, you're not required to allow medical marijuana card holders to hold those positions. A registered qualifying patient shall not be considered to be under the influence of marijuana solely because of the presence of metabolites or components of marijuana that appear in insufficient concentrations to cause impairment. This definition under the Arizona Medical Marijuana Act is what means that employers have to take extra steps when dealing with medical marijuana card holders to determine that they're actually under the influence. The Arizona Drug Testing of Employees Act is the piece of the statute that gets us back to the point where we can start to understand what impairment means when we're talking about medical marijuana card holders and how employers can actually function under that statute. So this statute defines impairment and safety sensitive positions. This is the piece of the puzzle that allows you to determine when a medical marijuana card holder is actually impaired by the marijuana that they're utilizing. Because at this point in time, we do not have a drug test that effectively tells us when an employee is actually impaired. There are several tests that are being touted as able to do so, but the science is still evolving. And at this point, we don't have a widely accepted or court-approved test. Okay? So we want to look to the statute definition of impairment, and then we also want to look to a safety-sensitive position. And we'll talk about both of those in depth. Okay. The Arizona Drug Testing of Employees Act also grants employers immunity from taking adverse actions against employees for positive drug tests if those tests are conducted in accordance with the statute. And it does not require employers to conduct drug testing. There's nothing in the statute that says just because you're allowed to conduct drug testing, you have to do so. This is just a safe harbor for employers who actually conduct testing and do so in accordance with the statute. The last piece of the Drug Testing of Employees Act that is important for us is it establishes testing policy requirements. This statute has 10 separate things that we'll talk about in detail here in a minute that each of your drug testing policies has to contain in order to be compliant. Under the statute, impairment means the following. It means symptoms that a prospective employee or employee while working may be under the influence of drugs or alcohol that may decrease or lessen the employee's performance of the duties or tasks of the employee's job position, including symptoms of the employee's following. And there's going to be a long list here, but I just want to kind of go through it one by one so that you can see the number of things that the statute actually intends for you to look at. So we're talking about speech, walking, standing, physical dexterity, agility, coordination, actions, movement, demeanor, appearances, clothing, odor, irrational and unusual behavior, negligence or carelessness in operating equipment, machinery, etc., disregard for the safety of employees or others, involvement in an accident that results in serious damage to equipment, machinery, or property, or injury to the employee or others, or other symptoms causing a reasonable suspicion of the use of drugs or alcohol. As you can see, this is a very extensive list. So it's important that when you're looking at this, you make sure that your managers and supervisors are aware of all of the factors that could lead into a determination that someone is actually impaired by marijuana. So when you break it out and you look at marijuana specifically, there are a lot of things that could be affected, right? So odor might be one of them. You might have the physical smell of marijuana after somebody returns from a lunch break. That by itself probably wouldn't be enough. But if you look at the totality of the circumstances surrounding the issues at play, you can add in things to determine that impairment could be likely. That would essentially be your basis to conduct reasonable suspicion testing and to support your position that an employee who tests positive for metabolites in their system for marijuana is actually under the influence at the time that the test occurred. The definition for a safety-sensitive position is any job designated by an employer as a safety-sensitive position, or any job that includes tasks or duties that the employer in good faith believes and could affect the safety or health of the employee performing the task or others, including any of the following: operating a motor vehicle, other vehicle, equipment, machinery, or power tools, repairing or maintaining, monitoring the performance or operation of any equipment, machinery, etc., performing duties in the residential or commercial premises of a customer, supplier, or vendor, preparing or handling food or medicine, and working in any occupation regulated pursuant to Title 32, right? And so that Title 32 is essentially any position that requires state licensing. You're going to see coordinated or regulated by Title 32. Now, one of the important things that I want to point out in this definition is, even though the definition says any position designated by the employer is safety sensitive, remember that this is an exception, right? So this is an exception to the discrimination that is prohibited by the Medical Marijuana Act. So you have to make sure that there's actually a functional basis for the determination of safety sensitive. We haven't seen a lot of those be challenged in the courts yet, but we expect that those will occur soon, and they will continue to happen until we have some reliable case law. So if you're tempted by this definition to designate every single position in your company as safety sensitive, I would highly suggest that you don't do that. The Arizona Drug Testing and Employment Act contains protection for employers who test, but as we said before, it's not a requirement to test. No action may be taken against an employer for acting in good faith on a positive test, for failing to test, for terminating a substance abuse or testing policy, and we're going to talk about why that might be important here in a bit, for acting on good faith belief that the employee used, possessed, or was impaired while at work, or excluding an employee from a safety sensitive position for a positive test. If you have a compliant policy, those are the specific actions that you're allowed to take under the Act, right? So a compliant drug testing policy under the Drug Testing of Employees Act must include the following 10 things. A statement of the employer's policy respecting drug and alcohol use by employees. Description of the employees or prospective employees who are subject to testing. The circumstances under which testing may be required. The substances to which testing may be required. A description of the testing methods and collection procedures to be used. The consequences of a refusal to participate in testing. Any adverse personnel actions that may be taken based on the testing procedure or results. The right of an employee on request to obtain a written test result. The right of an employee on request to explain in a confidential setting a positive test result. And a statement of the employer's policy regarding the confidentiality of test results. All 10 of these things have to be included within a policy. And so if you have a drug testing policy in your company that is reduced to a 1-paragraph policy and included in your handbook, it's likely not sufficient. As you can see from this list of the 10 things that are required, those 10 things themselves wouldn't fit in 1 paragraph. So if your entire policy is a paragraph or less, then you know that that's not a compliant testing policy, and you need to look at implementing a standalone policy that has all of these 10 requirements. That's if you're going to be testing, right? So now that we've had a review of the status of the law for marijuana in the state of Arizona, let's talk about the next steps. And part of that is creating your policies and procedures. The first action that you have to decide is whether or not you're going to test. When I started employment law, I actually started in the same year that recreational marijuana became legal in Colorado. And one of the things that we found was that a lot of employers actually had to decide not to test because functionally it wasn't an impact on their business if employees utilized marijuana outside of work. But they were reducing their applicant pools to the point that they couldn't hire enough employees. And a big example of this was skiing facilities, right? You try to hire a bunch of ski bums for the winter ski season and you exclude anyone who utilizes marijuana, and your applicant pool drops off significantly. So we did see employers that were affected by that, and they actually made the choice not to test, which is fine. And we'll talk about how you would manage a decision like that here in a minute. The next piece is to draft a compliant drug and alcohol policy. Even if you choose not to test, you still have obligations to inform your employees that you do not tolerate the use of marijuana or drugs or alcohol while at the workplace. And so regardless of the decision of test or not to test, you still have to draft a policy. And finally, ensure proper observation and documentation. So policies and procedures are only as effective as your managers and supervisors who are implementing them. So it becomes very important that after you draft a drug policy, you actually train your managers and supervisors on how to recognize impairment, how to properly observe, and how to properly document that impairment. So these are some of the considerations that you probably want to take while determining whether or not to test. There are some pros to testing, right? It's a very effective risk management tool. If you exclude anyone who tests positive, then there's not a better way to establish that you're not going to have an individual who utilizes while at the workplace, right? It gives you a definitive answer as to whether or not there was drugs or alcohol in that employee system. Cons, as we talked about, it could limit your applicant pool in your industry. And another con is that it can be very cost prohibitive. So testing procedures are not always cheap. And if you have pre-employment testing combined with random, any other sort of testing, then you're going to have a significant cost associated with conducting those. Some other considerations you might want to take are, do we have positions that necessitate testing, i.e. DOT or positions under a federal contract? Does it fit our culture? Some employment cultures are perfectly fine with an employee utilizing marijuana outside of work. They're perfectly fine with a culture that's a little bit more relaxed. Others are very adverse to having any sort of utilization of drugs or alcohol, right? So keep in mind who your company is and what fits with your culture. Lastly, can we manage use, possession, or impairment without it? And the simple answer is yes. So if you choose not to test, there are numerous other ways of managing the employee's impairment, and that's by focusing on the tangible job-related issues that are affected by utilization of marijuana, right? So, for example, if you have a customer service employee who you suspect is utilizing marijuana, you're probably not as upset about the actual utilization as you are by the fact that they may be showing up late for work. They may not have appropriate dress or attire while they're there, and they may not be as attentive when serving customers, right? So focus on the job-related issues that the utilization of marijuana actually causes. For those employers who test, the first step you have to determine is when are you going to test, or what type of testing are you going to conduct? There are several different types that are allowed. So pre-employment, post-accident, random, and reasonable suspicion are all types of testing that you can utilize. The statute, the drug testing of employees statute does not prevent you from utilizing any of those, provided that you explain that you're going to do those to your employees and you tell them when and how you're going to conduct that testing. Next, you have to determine the consequences. Identify your safety sensitive positions if you have any within your company, and are you going to require treatment? One of the things that the statute actually allows is that you can require an employee to seek treatment as part of maintaining their job with your company. So you have to make the determination as to whether or not you're going to do that. Non-testing employer need to focus and manage use and impairment based on job performance criteria, not suspicion, right? So as we talked about a little bit before, one of the things that we find is that people utilize suspicion of drug use when they're actually trying to focus on the production or the job performance issues that are caused by the suspected use, right? So whether it's attendance, production, appearance, hygiene, get back to the actual job performance piece that you're observing with the employee, as opposed to identifying that it's their use of marijuana, right? Off-duty use. Manage when it affects job performance and make a preliminary determination of how you're going to handle it if you see employee off-duty use on social media, right? So if you're going to say that an employee should not be allowed to post pictures of them utilizing marijuana on social media because of how it affects your company, you likely want to make that determination before it becomes an issue to ensure that you're handling it in a consistent manner. All employers need a policy, regardless of whether or not your company tests. As I said before, even if you're not going to test, you need to make sure that the policy is specifically tailored to your company's practices, and you need to make sure that you definitively state that utilization on the job is not accepted, right? Make sure that you review your policy with counsel to ensure that it is compliant with the Drug Testing of Employees Act. This is a very specific statute that has a lot of requirements, and you don't want to find out that your statute doesn't comply, or that your policy does not comply with the statute until it's too late, right? Manager training and documentation is essential. One of the cases that really reiterated this to employers is Whitmore versus Walmart Stores, Inc. That was actually an Arizona United States District Court case that was interpreting the statute. But what you have is an employee was utilizing medical marijuana, and she smoked the marijuana prior to bedtime for chronic pain relief and sleep aid. The employee has an accident at work where a bag of ice fell on her wrist. She notified HR, but does not seek medical treatment, and she does not believe any additional care is needed. 2 days later, the employee reports to HR that she is still suffering pain in her wrist. She testifies that she smokes marijuana at 2 a.m. the night before, the night she reports the continued pain. And then the next day at 2 p.m., the employee clocks into work and is sent to urgent care for an x-ray and a drug test. After returning to work, the employee notifies HR that urgent care did not take a photocopy of her medical marijuana card. The employee was terminated upon reasonable belief that her positive test result indicated that she was impaired by marijuana during her shift that same day. Okay, so the court held that prohibition of or protection that's in place in the Drug Testing of Employees Act to act on that positive test does not amend or repeal the sections of the Arizona Medical Marijuana Act that prohibit discrimination. So what Walmart was required to do there was actually show indicia of impairment at the time of the accident in order for that test to be valid in terminating the employee. There were several factors that didn't fall into place there. The first was that the drug test wasn't conducted until several days after the accident had occurred. And there was no other documentation or anything of the nature that would show that the employee was actually impaired at the time of the accident. So it's very important with Arizona Medical Marijuana Act that if you're going to use a drug test to terminate an employee, that your managers know that they need to be looking for signs of impairment at the time. And that's applicable to medical marijuana card holders, right? So always be mindful of uniform application and appearance of discrimination or disparate treatment. And that's one of the reasons that it's important to train up managers and supervisors. So we just kind of ran through the state of marijuana law in Arizona. There are a couple things that we need to be mindful of in the future that are really going to change our stance on this issue and how employers need to act. The first is watch out for a reliable and uniformly accepted test for impairment. Technology is rapidly improving. I've seen numerous reports of tests that are touted as being able to actually show marijuana impairment at the time of the test. Everything from an eye laser that shows that you're actually impaired to there's a breathalyzer that's supposedly coming. There's a lot of things that are in the works. And once that comes into play, you'll see that, number one, the indicia of impairment actually becomes less important, right? It goes back to alcohol, where you can utilize a standard test to show impairment. We don't currently have it, but it's on the horizon. So that'll definitely change the landscape. The next thing is a change in federal law. So as many of you may or may not know, the House actually passed legalization of marijuana last year, 228 for and 164 against. We'll have to see how the changes in the House of Representatives and the Senate and the presidential administration affect this. And I think realistically, it's more likely that you move towards federal passing of marijuana than we were last year or the previous administration. The other thing to keep in mind is that a Forbes poll actually shows that there's an approval rating for legalization of marijuana across the board at a rate of 2 out of 3. So once that all happens, I think you're going to see a lot of differences in this landscape. So with that, I've pretty much finished up my prepared materials. So if anyone has any questions.
Yeah, so if anyone has questions, if you'll use the Q&A box or raise your hand, virtual hand. The one question I wanted to ask you is there a source that provides sample policies that are in compliance with DTEA?
So Employers Council does actually have sample policies. Of course, we can only share those with our members. I don't know of a source that has any publicly available. Obviously, there's numerous employment law firms that would have policies that they can tailor to yours. But what I want to really stress is the importance of the tailoring. So even Employers Council with our standard policy, that's a starting point, but those do need to be specifically tailored to how each company actually handles those issues. Otherwise, they're not going to be compliant. So it's not something I would risk going to Google and printing off a policy.
Sure, perfect. Other questions? Anything in the Q&A? Okay. All right. Well, with that then, Glenn, I just want to thank you for your guidance on the topic. It was a lot of things to think about, and a lot of things that we can take back and review even existing policies that we have and make sure we're thinking about this aspect as well. We have Jennifer Graves from the town, and so quickly, because she's a partner, I just want to give her a few minutes to introduce herself as well.
Thank you so much, Sarah, and apologies again, everyone, for being late to today's webinar. Thank you so much, Sarah, for letting me speak afterwards. And thank you, Glenn. What a great presentation, and certainly very timely for what's happening, and hopefully very helpful to the business community. But I just want to thank the Chamber for their continued partnership. This has been an amazing series, and we love doing this with you all. And I did want to just mention to folks on the call, on the webinar today, in case you're interested in our recovery programs coming out of the town that we've been partnering with the Chamber on to survey the business community and try to find out what the needs are out there. The second round of the Gilbert Together Relief Grant will be launching next week. So the grant application process will open up again on February 1st. And we also still have a loan program, as well as recovery and technical assistance. So thank you so much, Sarah.
Perfect, thank you. So once again, just a thank you to our series sponsors, Dignity Health, Phoenix Mesa Gateway Airport, Cox Business, and Arizona State University. And of course, big thank you to Glenn. And with that, we will conclude our series.
Thank you for having me.
Thank you so much.